4 o'clock. My name is Jordan Walker. I'm with the law firm of Seaver Story Walker, and today we are going to talk about the Heartland Greenway pipeline, eminent domain, and what to expect in your fight with the pipeline as it unfolds over the next couple of years or so, depending on when it starts. Again, my name is Jordan Walker. I'm with the law firm of Seaver Story. We're going to go ahead and get started with this presentation. Okay. So real quick, before we get into the pipeline, I just want to give a background of what our firm is and what we do and why you should be listening to us. Seaver Story, actually it's Seaver Story Walker now. We are attorneys for landowners faced with eminent domain acquisitions, which include road projects, pipelines, power lines, really any public works project or utility project can utilize the power of eminent domain. That's generally what we work on. We have done hundreds of road project cases, hundreds of power line cases, hundreds of pipeline cases. So as a consequence, we've learned quite a bit about eminent domain, how these companies operate, how these condemners operate. And what we're going to do here today is relay what we've learned. But not only do we have experience with eminent domain, we have experience with specifically pipelines utilizing the power of eminent domain. There is a case that I handled, or a project that I handled down in Southern Illinois and Missouri, and that is called the Spire pipeline. That's actually ongoing as we sit here today, but that involved a large landowner group, a large group of landowners rather, that we represented against the pipeline to ensure that they got the best deal, along with assisted them with language and anything necessary to the project. And then also another pipeline project in Illinois, we worked on the Dakota Access. That's obviously more closer to this area of the state for this project's purpose. That was pipeline Illinois, Iowa. And we represented, again, another 40 plus group of landowners against the Dakota Access pipeline. And we were successful in getting them deals as well. And then here's another list of projects down here at the bottom. These are all projects that we have worked on. These are all utility projects that we have worked on across the country. So as a consequence, like I said, we've seen these a lot. While carbon capture pipelines are a new phenomenon, they're expected to follow the same path and procedure that builders of any pipeline, natural gas, oil, you name it, ammonia, they all follow the same script, and we are expecting this pipeline to follow the same path that those did. So real quick, let's talk about what the Heartland Greenway pipeline is, if you're not aware. The Heartland Greenway pipeline is a carbon capture pipeline that's carrying, I believe, CO2 that has been acquired or captured from the atmosphere, and they are sequestering it here down near Springfield to the east of it in a natural gas storage cavern underground. So this is a new type of pipeline. Usually pipelines carry gas, natural gas, oil, energy producing substances. This is carrying away carbon that's been captured. It's a little bit different, but again, we're expecting the same process and procedure on this project. It is a very large pipeline. It's 1,300 miles, and it ends down here again in the middle of Illinois. 240 of those miles are in Illinois. I think there's about 2,000 tracks that are affected by this project. This project, as we sit here today, pipelines in Illinois, like any utility projects, have to go through a permitting process. They need to get approval from the ICC, which is the Illinois Commerce Commission. They are responsible for permitting these types of projects. And we are expecting them to file their permitting application this year with the Illinois Commerce Commission to get approval to build the pipeline. We expect right away, which is acquiring the land, to begin this year. If not, I would expect that they'll start coming out and making offers here shortly. I would imagine this summer, if not maybe the fall. There's a planned in-service date of 2024 to 2025 that's in the ground, moving gas. A lot of these schedules are usually, they tend to lean on the ambitious side. So while they say they're going to be ready and done by 2024 or 2025, there's a lot of moving parts between now and then. So I wouldn't bank on that being the case. Sometimes usually takes a little bit longer than they predict or project. It is going to be 5 feet underground, and it will be the pipeline will be between 6 and 24 inches wide, depending on where you're located along the line. Here's a good, I guess, image of the timeline, the schedule that Heartland Greenway, which is the name of the pipeline, owned by Navigator CO2. They're the owners of the pipeline. This is their schedule. And as you can see, as we sit here today, we are right in the middle of the schedule. In fact, Q3, Q4 of this year, you can see that right-of-way easement acquisition is scheduled. Again, so that would be the latter half of this year. We'll see. Again, I expect them to be out there, at least on some parcels here shortly, but it is a big project, a lot of parcels, a lot of landowners that need to be contacted. So consequently, these schedules tend to change, but this is the information that we have, which means to be ready or be prepared for when they come in and start making those offers. The easement that they're going to seek, and the easement is the document that will grant them the right to be on your property and to build the pipeline. They are looking for a 50-foot permanent easement, which, as you might imagine, is permanent. It lasts forever. It will run with the land. It will convey to your heirs, or if you sell the property, it will be there. They will have to deal with it. Whoever takes possession of the property in the future. So they're looking for a 50-foot permanent and then a 50-foot to 75-foot temporary easement on either side. And that, as you might imagine, is a temporary easement. It will expire generally either 2 years or when they're finished building the pipeline. So as part of this easement, and they are going to make an offer. So they're going to offer you some amount of compensation to get you to sign over that easement to them. And based on our read and based on our research, they're going to offer you money for the land itself that they're using. They are anticipated to offer 3 years of crop damages at a diminishing percentage, I believe from 80 to 60 to 40, something along those lines, for 3 years. And then they might, although we don't know this for a fact, it's just possible that they will offer a signing bonus to get you to sign earlier rather than later. And that is on purpose, as we'll get into, because the goal of these right-of-way agents and the goal of Navigator and the pipeline in general is to get these easements locked up as soon as possible. So they are going to do what they need to accomplish that. However, a lot of times they will avoid large they'll avoid issues with compensation that could result in them having to pay quite a bit more money than they want to. And we'll talk about that. But this is when they come out, when the right-of-way agents come out and start talking to you about your land and talking about acquiring the property, this is kind of a rough ballpark for what you're going to look for in that offer package. And we'll talk about why this compensation package is not going to be enough money for you when they come down with those offers. Before we get into that, though, I want to talk briefly about easements and how important they are. So easements, like I said, an easement is a document that conveys a right to be on the property, in this case, to build a pipeline. Easements can be used for a number of different reasons. They can be used for access easements. Those are typically driveways where a neighboring property might not have access to a road, wants to get access to the road, and therefore has an access easement over the neighboring property to get to the public road. And that's just an example of an easement, and that is it is again it's a right to be on the property for a certain purpose. An easement by itself is just a document conveying some right. And the question that I get in these situations, power line, pipeline cases, what are they allowed to do? Are they allowed to do this? Are they allowed to do that on the land via the easement? And the response I give every single time to that question is, it all depends on what the easement says. What rights are you conveying to Navigator in the document? And at the end of the day, that is the only thing that matters. It doesn't matter what the right-of-way person promised you. It doesn't matter what they said. It doesn't matter about assurances given. It doesn't matter about what's fair or what ostensibly the purpose of the project is. What matters is, what does that easement say? And what rights are you signing away? So when I talk about what does it say, I mean, what does it define what the pipeline or the holder of the easement can, cannot, or must do? Does it define where the pipeline can do what it needs to do, what you've granted it the right to do? And does it define when and how long they can do it? So it's a question of what, where, and when on each easement, on an easement document. What are you conveying? What are you specifically giving them the right to do? Where are they allowed to do those rights that you're granting them? And then how long are they allowed to do them? So those three terms need to be defined. If they're not, then you're probably going to run into trouble. And it's important to remember that there's no going back on these cases. There's no going back once the documents are signed. With the permanent easement is going to be there. You can just be assured that it's going to be there forever, or pretend like it's going to, because for their purposes, it will be. It's important to note, and I guess to be skeptical when the pipeline approaches you about getting this easement, because they are undoubtedly going to sneak in what I've dubbed unauthorized language, or language that they do not tell you that they're going to do, or seemingly have nothing to do with the pipeline itself. So, for example, a very common clause we see in easements that are presented to landowners and right-of-way agents ask landowners to sign is a fiber optic clause. And it's right there on the PowerPoint. And what fiber optic is or a clause rather, is almost always the first easement they give to the landowners is going to include something in there that says the pipeline is allowed to, or its third-party agents or anyone it leases the land to can run fiber optic in the easement area, which would mean cable companies, fiber optic cable, running internet effectively through the easement. And there's going to be a virtual, not guaranteed, but one very common clause we see in these easements is that the pipeline company, or any way they sell the rights within the easement to, can run fiber optic through it. You might ask yourself, what does fiber optic cable have to do with the pipeline? The answer is it has nothing to do with it. But if they are able to trick landowners into giving them this right to run fiber optic through the easement, then that's good for them, because then they can then sublease that right to a cable company, and they get some sort of money that they've reached with that cable company, some amount of money, and then you don't get anything because you already gave them the right to do that when you signed the document. So that's just an example. It's one that we see all the time. Another example, I've seen easements that grant not one, not two, not three, not four, not five, but as many pipelines as they want on the entirety of the property, and not just the 50-foot easement. Again, you might ask yourself, well, that has nothing to do with one pipeline. This is only one pipeline. Why do they need the right to do 2, 3, 4, or 5? Again, it's not necessarily for them to do it, but it's so that they have the ability to do it, because then if they have the ability to do it through this easement, they can sell it to somebody else and have them come in and do it. And you can't do a thing because you already gave them the right to do it and to sell it. And so these are just examples of easement deficiencies that I have seen quite a bit. we haven't seen any easements on this project yet, but I would anticipate some sort of language that is not appropriate for what their goals are, their stated goals, and that is to build a carbon capture pipeline. And you might say, well, what about the right-of-way agent that came out and talked to me and my family and said that this is only for one pipeline? We're not going to run fiber optic. Don't worry about it. And then down the road, they're doing that. What about those promises that the right-of-way agent made? And the answer is that those are irrelevant. Verbal promises mean nothing. What matters is what the document says, what the easement says. And if the easement gives them the right to do it and you signed it and they signed it, that's it. It's a contract. Do not assume that right-of-way agents, and that takes me back to a larger point, do not assume that right-of-way agents are on your side no matter how much they say it. Their job is not to help you out. Their job is to get your land for as cheap as possible. And that is what they get paid to do. So just keep that in mind when they come in and they start talking about how, they're not going to do this, they're not going to do that. It's not how it works. What matters is what it says. So now that we've talked about easements, let's talk about money, because that's the other aspect that needs to be, I guess, that requires some attention during your anticipated negotiations. Every pipeline compensation package should include at least three things. You should have some sort of money for lost crops. Like I said, we expect them to offer these, but if they offer as they state they will, I don't think it's going to be enough. They're offering 3 years at 180 and 60% of crops. That's not going to be enough. This pipeline is going to be put into the ground, and if it is remediated correctly, it's still going to be a very hot pipe, so to speak. The land will be warmer. It'll be difficult to grow crops just as a matter of the circumstances or how the easement will sit now that it's got a pipeline that's at whatever number of degrees right below it. Crop damage will suffer and sustain for longer than 3 years in my estimation. So it's important that you get paid the extent to which the anticipated crop loss is expected to be. They're going to offer you money for the land taken, or this should be part of their compensation. And that is just the value of the land, the amount of land they're taking, and whether or not the amount offered is reflective of the fair market value of the land in the area. And then finally, and this is an aspect that I guarantee they're not going to offer, and that is called residual damage. And I'll give you an example of what residual damage means, or compensation for the impact on the land. If you have a 50-acre tract and they are running the pipeline right through the middle of it, let's say they need 2 acres, they go right through the middle of the 50-acre tract, effectively dividing it into 2 tracts, that has an impact. That has an impact by bisecting the parcel. That has an impact by installing a pipeline on a previously unencumbered lot. Whether, ultimately, as the market bears out, buyers of farmland, buyers of land generally don't want to deal with pipelines. They don't want to deal with easements. They don't want to deal with all the issues that may come down the line, whether it's explosions, cracks, leaks, fires, etc. Whether or not they're actually going to happen, landowners don't want to deal with it. So as a consequence, what happens? They pay less money for these lots. And that is something that, again, the pipeline is not going to offer because the pipeline doesn't believe in it. And they will steadfastly just deny its existence. And in fact, you'll have to bring it up. You're going to be the one that's going to raise it. And even then, they're going to say it doesn't exist. They're going to say that the market doesn't bear it out, et cetera, and so forth. But it's important to know that in our research, this residual damage does exist to some extent. And you need to get paid for this impact because there's no going back once you sign the documents. So let's talk about some things that you should do, some things you shouldn't do. What you should do, have a legal professional review your documents. These are, by their nature, legal documents. These are land conveyances. These are property documents, conveyance of real property. and they are very unique documents. They are not. It's not like selling your home. It is selling a very specific type it's a very specific type of conveyance that is not boilerplate language, that requires tailoring and crafting to make sure that it's accurate. So as a consequence, it makes sense then that you should have somebody look at it that knows what they're looking at. So definitely have somebody at the very least. If you're not going to negotiate, you don't care about that, you just want the documents to be right, then at the very least you need to do that. And make sure that you're not signing away the farm based on what they're telling you. And that leads me to what not to do, and that is do not take the pipeline's word for it. And that goes for anything. Anything they say, anything they do not take their word for it. Assume that they're lying. Whether they are or not, assume that they're lying and then get some advice on how to move forward. Do not take them at face value. Do not work your way through negotiations with them alone, because you will end up in a situation where your easement is poorly crafted, you're not getting the right amount of money, or some other issue that arises. Just it is not wise to follow the word of the right-of-way agent that is working for the pipeline. And then second do and don't. Enlist a professional to negotiate on your behalf. That's something you should do. You are in a unique situation as a landowner affected by this pipeline. This pipeline that, as of right now, does not have eminent domain authority, but if and when they get the ICC approval, which would be expected and anticipated, they will have eminent domain authority, which means you are not in a situation where you can just tell this pipeline, no, we're not doing it forever. Because eventually they are going to get the power of eminent domain and they will file suit against you to get your land. Now, in Illinois, they cannot do that yet. They don't have the ability to do it yet. But once they do get the ability from the ICC to do it, and you're sitting out there and you've been ignoring it or avoiding this the entire time or rejecting it, they're going to file a suit against you. And then you got to handle your case in court, and things get exponentially more difficult at that point. So just keep that in mind, that this is not a traditional arm's length transaction. It's not a situation where you can just tell them to buzz off forever, because if you do that, you're running the risk of getting in a situation you don't want to be in. But at the same time, and when you're dealing with the right-of-way agents, bear in mind they're going to do certain things. And one of those tactics that they employ is hurry you into a decision, saying you got to make a decision by X. You got to respond in the next week. Give me an offer. Respond. Let's talk. They're going to bug you. They're going to call you every week. They're going to stop by unannounced. They're always going to be there until you get an attorney, and the attorney tells them to stop. But they are going to keep bugging you because that's their job, and they are successful in their bugging of landowners, so they keep doing it because they know what works with landowners and how to get their properties. So do not be rushed into a decision, but also it sounds like competing advice, but there's a little nuance to it. Don't get rushed into a decision, but at the same time, do not just ignore the situation. Again, letting it sit gets you into trouble. And then rushing into a decision also gets you in trouble. The easiest path that, in my view, and of course this is self-serving, but the easiest path that I see for a landowner and where they get the best possible result, not have to worry about it and make sure that it's being addressed and not just being put on the back burner, is to hire an attorney. Hire somebody who can review the documents, negotiate on your behalf, and handle the right-of-way agents also on your behalf so that you don't have to. And so then when your attorney comes to you and says, okay, here's the deal that we got, here's the language that we got added, I think this is a good deal and you should sign it, you sign it and the deal's done, and you didn't need to stress over it, you didn't need to worry about it, and you got into a situation where at least you have some added protection of counsel to help you through it and to give you some insurance against the documents and everything. And finally, and of course, to ensure that you got the best deal possible. So And then my final do and don't, and and with this, I'll leave you. The first thing that I recommend, well, the final thing that I recommend that landowners do, if possible, and it's not always possible, and as a matter of fact, it's usually not possible, but I would advise, if possible, to get your neighbors together. Go to your neighbors to the south, go to your neighbors to the north, go all around to the folks that you know that are affected by the pipeline, and form a group. If you can form a group, you increase your bargaining position, you increase your leverage and your negotiating power. You know, if for example, if I go to Navigator, the company that is going to own this pipeline, that does own this pipeline, if I go to them and say that I represent a couple landowners here and there, you know, okay, they're still going to give me the due respect necessary. But if I'm able to go to them with, you know, 100 or 150 landowners, that's going to be a big deal. That's going to be something that they're going to have to deal with, and it makes it much more likely for a good result, a positive result, for all of the landowners in that group. If there's more landowners in the group, power is leverage, and leverage equals more money, better language, better results. It's not guaranteed, of course, but again, it just increases your possibility of a positive outcome, or as positive as it could be or will be. So if you can, great. If you can't, of course, it's not a big deal. We hope to have a large group of landowners, so whether you can arrange it on your own, or not, if you sign up with our firm and we have a large landowner group, you become part of it without having to do anything. Something to think about now while we're in the early stages of this pipeline, this project. But now would be a good time to start talking to your neighbors about the pipeline, whether they're affected, and if they want to stick together and go with the same council. So with that, again, I will leave you. This is the end of our presentation. This says, so what I would advise landowners right now that don't have an offer, sit tight, start talking to your neighbors that you know are affected, start to maybe create a group. If you want to reach out to me, talk further, happy to do it. That would be a good course of action as we sit here before offers are made. But once the offer is made, that's when you need to start contacting attorneys. You can contact me at 888-318-3761 or jordan@landownerattorneys.com. With that offer, I will look at it for free. I will look at the easement for free, and I will give you my thoughts on both, and whether I think the money is satisfactory, whether it's good, whether it's bad, how bad it is, and what the easement language looks like as well, whether or not it's good, bad, or terrible. So I'm happy to do that for free. Just shoot me an email, give me a call, and we can talk about it further. Okay, well, thank you so much, everybody, for stopping by. Again, my name is Jordan Walker. I'm with Steve Story Walker. If you have any questions, feel free to give me a call, shoot me an email. Other than that, thank you for stopping by, and good luck.